former Deputy Achtyl was sentenced last night out in Orchard Park Town Court. The judge in this case pretty much just took what the probation department in their PSI, their pre-sentencing report investigation, recommended. Every case that's a misdemeanor or felony before someone is sentenced, the probation department does what they call a PSI, which is a pre-sentencing investigation. A pre-sentencing investigation was done in this case. I was given a copy about a week in advance. The pre-sentence investigation recommended a conditional discharge with 150 hours of community service, along with anger management classes. The judge pretty much mimicked what the PSI stated, except the judge did not order the anger management classes. He just ordered the 150 hours of community service, and he imposed a fine. Upon reading that PSI, I disagreed with it. I told my attorneys last night to go into court and say that we disagree with the PSI, that we disagree that a conditional discharge is an appropriate sentence in this matter. The victim wanted to speak in this case, so we made the tactical decision to allow the victim to speak first. The victim, as you all heard, spoke first. The victim, I thought, was very eloquent. The victim could not have said any better when the victim said that I had to spend a night in jail for doing nothing. And that's an important point here. I think it's been lost. What's been covered, obviously, mainly is the fact that, the victim got beat up here, got hit with a baton, got a concussion, got a broken nose, and was all bloodied. But let's not forget that the victim was arrested that night. And the victim was taken to the holding center and spent the night in jail, and then came to court in Orchard Park the next morning and was then released. So the victim spent a day and a night in jail. And the victim, as I said, I could have said it better myself, the victim said that I believe that Deputy Achtyl should get what I got, time in jail. And when it was our turn to talk, my lawyers stated that, Judge, we disagree with the PSI, and we stand behind Mr. Balsito here, our victim, and concur with what he said. And then we left it at that. Now, I'm not going to sit here and grandstand and pound my chest and say I'm outraged that he didn't get jail, because, let's be honest, we knew going into this thing he wasn't going to get jail. There was no one in this situation where it's your first offense, never been in trouble before, et cetera, has ever gotten jail. And so jail was not inappropriate here, but jail was not realistic. And so in order to have credibility with the judge, I didn't want my people standing up there saying, Judge, we want the max 2 years in jail, hammer him, throw away the key, because we would have lost credibility then. And I want my attorneys to have credibility when we are making sentencing recommendations, which was, at the end of the day, I would have liked to see probation. That would have been the middle ground here, all right? I mean, the judge had three choices: jail, probation, and a conditional discharge. There's a thing called an unconditional discharge, but in my 4 years as judge, I never gave that. I've never seen that given at all, so it's really not a reality. There's three options here: jail, probation, conditional discharge. And I would have liked to see probation.
You said that you wanted to stand behind Mr. Balsito.
Yes.
As he went through that. Nicholas wanted some jail time.
Yes.
For Achtyl.
Yes.
Are you saying that you wouldn't have even wanted, say, one night in jail?
Oh no! I have no problem with him going to jail. Okay. Oh yeah, no. It just wasn't realistic.
Gotcha.
Okay. This wasn't realistic. And again, I didn't want to. I didn't want to grandstand there in front of the judge and kick and scream about jail when that would have put the credibility of my lawyers at stake.
Sheriff Howard, after the conviction first came down, he really went hard against you and criticized you for going after his office in this situation.
Yep.
It's been about 3 months since that's happened.
Yep.
Has there been a better relationship between your office and his office, or would you say it's about the same?
Oh no, there was no bad relationship even after that happened. I mean, he took a couple shots at me there. Okay, I mean, it was his guy. I get it, but him taking a couple shots at me 3 months ago did not affect business at all. Our business, the relationship we have with the sheriff's department, the investigations we conducted, the way we interact every day was not changed one iota. He just took a couple shots at me. I get that, but I think what's important to note out is that obviously he came around last night. I mean, he came around last night and for the first time admitted that, hey, my guy obviously made a wrong decision here. Now he tried to, him and Achtyl's lawyer, they tried to couch it as a 30-second momentary lapse of judgment. Well, it was more than that. All right, let's be honest here. All right, we all again focused on the young man being beaten and bloodied. All right, and we forget that he spent a night in jail. We also focus on the assault, is what occurred, which did occur in about 30 seconds. I'll concede that, but let's not forget that after the dust settled, after everyone calmed down, and after the adrenaline was all gone down, at a later time, a much later time, former Deputy Achtyl went to wherever and completed an official document regarding what happened to cover up basically his arrest of Balcedo, and lied on that form and committed the crime of falsifying an official document. That was not done in that 30-second adrenaline rush, okay? That was not done in that 30-second moment of judgment lapse. That was done at a later period when the adrenaline was down, when the dust had settled. So it was more than a 30-second lapse of judgment.
Moving forward, now this happened over 2 years ago. There's a lot more officers wearing body cams now.
Yes.
So stepping back and looking at all the publicity this got and what effect the cameras had, but also saying that the guy never got jail time, how do you think this will serve as an example or not an example for cops wearing body cams?
I think that obviously I disagree with the conditional discharge, but I still think that the main message that was sent out there, and that's out there, is that he was arrested, he was brought to trial, and he was convicted. And I think that message right there that is out there now is going to not only alleviate fears in the community that, if a police officer commits misconduct, that it's going to get shoved under the rug. It also, I believe, and I think that body cams in general too, that I believe that body cams have the ability of putting officers on their toes and making sure that they dot all their I's and cross all their T's. And so I think that there's a lot of different messages that have come out of this whole thing. And I think that we have to be also aware of the fact that if there was not a body cam in this case, there's a good probability that he may have been found not guilty. Because if at the end of the day, all I had was my victim's testimony and the testimony of two of his three friends who were there, who again, were all drinking at a Bills game, we're all hanging out, partying, all right, and it's them on one side testifying, and then it is the officers on the other side testifying without any body cams at all. You got a he said situation here. You may not have the same result. Again, I'm not saying that people would have thought my people were lying, all right, but let's be honest here. You may have not had the same result. So the body cam in this case obviously was a crucial piece of evidence. Why do you think Sheriff Howell was so upset that it came out in the first place, all right? I mean, let's be honest here. That's the reason why he was upset that body cam got out, because the body cam showed that his guy was guilty. Let's call it the way it is. So the body cam footage obviously was a key piece of evidence here, and body cam footage going forward is going to be a key piece of evidence in many trials that we're going to see here in not only Erie County, but across the state, across the country.
Because the body camera was released on the civil end of
Yes.
the lawsuit, does that, I guess, concern you that because there was, say, the criminal case with this as well, it's almost like a trial by the public, though? I think that's kind of the concern that the sheriff has.
Yeah, that's valid. That's valid. So, I mean, the fact that the body cam footage was out there, does have a potential to pre-taint a jury. Yes, that's a valid point. Obviously, when you are conducting jury selection, you need to ask the questions of all the potential jurors. Have you seen the body cam footage about this case? If so, what was the context that you saw it in? Have you drawn any conclusions from what you saw? Are you going to be able to disregard that and come in here and only listen to the evidence that you're going to get in this trial and put aside any preconceived notions that you may or may not have had, all right? All those kind of questions need to be done in voir dire, all right, when you're picking a jury. And, both sides have to, and the judge has to make sure that when you sit the members on the jury now, that either, hopefully they didn't see it ahead of time, but if they did see it ahead of time, that they are willing to disregard that and only evaluate what they're going to see at trial. And that's a challenge sometimes, but if you do a good job on jury selection, if you make sure that you get truthful answers out of jurors and you screen them well, I think you can overcome that.
Can we ask you about 2-year-old Jordan Robinson? Whatever you can say about that. Can you confirm how many bruises?
Yeah, there were hundreds. There were lots of bruises. Yeah, the autopsy showed that there were multiple bruises, lacerations on his body. The felony hearing was conducted yesterday. The matter was held over now for a grand jury. So now it is now in my court now to go forward with the investigation, and the investigation does continue to go forward, and to now put the matter in a grand jury. So that's where we are procedurally. But I can't really talk more about any other evidence out there, but I can confirm that we have the results of the autopsy. The autopsy lists the cause of death as multiple blunt force trauma, and when I say multiple, George, it's multiple.
Anything you could say
with a
about,
capital M.
Yeah.
anything you could say about the Grape Street trial that's ongoing, when you're expecting it to finish?
Yeah, it'll finish this morning. So that both sides rested. Closing arguments are scheduled for today. So unless something dramatically happens or someone gets sick or something, I anticipate that the closing arguments will be concluded today, and that the judge will then has already indicated he's going to reserve decision, which most judges do on bench trials. They don't make a decision right away. So he'll reserve decision, and then he will let the parties know, and then we'll let you know when he's going to come back and make his decision. It's normally a week or so out.
Okay.
I mean, that's normal, but it's up to him.
I have a comment on Vasquez. Just, I guess, in the sense of, there's state law prohibits the public from viewing the personnel files, for like Deputy Achtyl or officer, and so
Yeah.
do you think in the interest of transparency, there should be allowances, or people should be allowed to look at the files?
Well, the
Or record or something.
the problem with that is that there is, there's always litigation involved in that kind of stuff. Okay, so there's been multiple court decisions, not only across the state but across the country, on what records can and cannot be released. All right, so I'm not going to comment on that in the sense that I'm going to abide by what the courts say and what the court orders are. So, again, every case is unique. Every situation is different, all right? And so if a court at some point orders that this can be released or that can be released, then we'll follow the court orders. But I'm gonna wait and see, and just I'm gonna adhere to the court decisions on that.
Earlier this month in Albany, there was a bill that was introduced called the Elder Parole Bill. I don't know if you've had a chance to look at it.
Yeah, that's the one where they if you serve 15 years, that when you turn 55 years old, that you'll be eligible for parole no matter what the sentence is.
And regardless of what
the crime
conviction
is.
was,
Yeah.
What's your thoughts?
My gut is I don't like it. All right, that's my gut. All right, but to be fair, I haven't read the bill yet.
Okay.
I haven't read the bill yet, so let me give me a chance to read the bill and find out exactly what it says. There may be exceptions in there or something. All right, but obviously, I can tell you that if an individual is murder someone or rape someone or commits sexual abuse on a child, which are my big three, and that individual is doing 25 years or 25 to life, and they have done 15 years, so that would put the individual at 40 years old. Worse, like for the least age scenario, if a 40-year-old individual committed murder, raped an individual, sexually abused a child, and they got 25 or 25 to life in prison, and they did 15 years. Now, at 55 years old, just because they're 55, they're going to be let out of there, all right? Not under my watch. The argument is a little different now if an 18-year-old did it, okay? If a 17-year-old did it, a kid. If a kid, shot someone, all right? And now a kid, who was a kid when they committed a crime, albeit a heinous crime, all right? But, it was a kid. And they've done, 40 years in jail now, 38 years in jail, whatever the math is, all right? They've done 38 years in jail now, and now they're 55 after doing 38 years in jail, and they have turned their life around in prison. They've gotten a GED. They've become a preacher in prison, and they're given Bible study classes every week, all right? And we look back and say, hey, this kid was a child. He was an abused child. He came from a single mom. He had nothing. He was in poverty, and yeah, he did something wrong. Now I'm more open to look at that, all right? Like I said, as you all know me, I'm a reasonable guy, all right? I'm open to look at that, but I'm not open to look at a 40-year-old man, a 40-year-old woman, an adult who commits murder and now 15 years later wants to get out because he's 55. That ain't flying. But with that said, let me read the bill.
Sure. The new discovery law, I know we've asked you a lot about it. You've spoken a lot about it. How's it going as of this week? And specifically that 15-day discovery window, I know puts a load on some police departments. So how's it going?
It does. It's there. I am not having that many problems, all right? I mean, listen, there's problems out there. There's issues out there. We're working through it. But, I created a whole new bureau here for this task. And I've got one of my senior assistant district attorneys in charge of this bureau now. And I've hired, because the county ledge was, good to me, I hired 18 new people to do this work. So it's working out okay with me. Mm-hmm. Now, with that said, though, George, it's a little unfair. I mean, by me saying that, it's not fair to my colleagues across the state because my colleagues across the state are having major problems, especially the smaller counties in New York State. They don't have the luxury that I have of 18 new hires. They don't have the luxury of a big organization that I have here with an established system of getting all this documents here, and the ability for me, in addition to the 18 new people, I've also spent about $80,000 on new computer equipment, where we've been able to get all the police agencies out there to upload their documents into a cloud, and then I go in that cloud now too and get it. So we've streamlined all this. I have the ability to spend $80,000 on a new cloud, and new computers and new monitors. My friends and colleagues in the smaller counties across New York State don't have that luxury, and they're drowning. They're having major problems.
So if you need interrogation tapes from a suburban police department or something, they can send maybe the whole thing to you on the cloud, and your people here.
I get it that day.
Yeah.
Oh yeah, I'm getting it right away. Yeah, yeah. So I'm, and again, I set up a task force 6 months ago in July. So we had a task force established in July, and we've been preparing this thing for 6 months. I also didn't wait till January 1st, in the sense that I staggered it in, meaning that as of August 1st, we treated 1 out of every 20 cases under the new rule. September 1st, 1 every 15, October 1 every 10, November 1 every 5, and December every other case. So we've been doing the new discovery since August 1st. So again, we're okay here, all right? But that's a little that sounds a little arrogant when my colleagues downstate hear that, especially in the rural counties. So I'm not going to. I was on a conference call yesterday where my colleagues in the small counties are drowning, and they need help. And there was a blurb in the state budget that is going to take $2 million from the Manhattan DA's office and use that $2 million now to give to all the DAs statewide for computers and for IT software. Well, first of all, the Manhattan DA shouldn't be paying for it, okay? I mean, the state should pay for that. It's not fair to Cy Vance in Manhattan for him to foot the bill for the whole state, all right? So I get it that Cy's got a lot of money because he lives in a different world than we live in, where they prosecute big banks on Wall Street, and these big banks now pay fines into a fund that he has. So I'm not crying. I mean, he's not poor, but he shouldn't be paying for this whole thing. The state should be paying for it. And $2 million isn't going to do us any good. Like I said, I'd have spent 80 grand on my own already. The New York City, 5 boroughs in New York City probably spent double that already. So between the 5 boroughs in New York City and me, we've probably already spent the $2 million right there. What does that do for my friends in the middle of the state? Does nothing. So the state, but I will give the state credit that they obviously recognize that we need money for this. So they recognize that, just as a governor recognized yesterday, we got to make tweaks to the bail law. So I mean, so obviously Albany now is waking up to the fact that we need money and resources for discovery, and we need to make tweaks to the bail statute. I'm not advocating blowing it up. The reforms are fine, but we need to make some tweaks to both of them. And on the latter end, the discovery, we need resources. And hopefully we'll get more than $2 million. Anything else? Okay.